Welcome to the House Judiciary Committee, non-civil. We have a few bills on the agenda this afternoon. Let me first, as a matter of courtesy, ask you if you've got a cell phone, BlackBerry, whatever, if you put that in the quiet or silent position. We'd sure appreciate it. It's a fairly small room. Let me also recognize our judges of the week, Judge Tom Campbell from the Superior Court here in the Atlanta Circuit. Judge Campbell, welcome. Judge Campbell is a former member of the House, served 14 years, as well as I think the entire tenure on the Judiciary Committee as well. So it's good to have an old friend back here, and also as a resource to all of us on both sides of the aisle. Let me also recognize Judge Fletcher Sams from Fayette County, the state court judges. Thank you, sir, for being here. We look to you as a resource just as much. The charge here, we give the charge here, is if you see something that we don't, we ask you to pipe up and to let us know, because you're on the ground seeing it. We're seeing words on paper, and sometimes, as we've said before, the translation between words on paper and operational implementation are different, right? So that's where we look to for that guidance and that direction. So we appreciate it very much. We'll kick off with House Bill 901, Representative Levitas.
Do you want me to do it here? Or?
No, I'll just stick there. It's fine. I appreciate it. We don't need to. But thank you for asking.
Thank you, Mr. Chairman. I bring before the committee House Bill 901. 901 simply strikes 5 words. I'm sorry, I guess there's 6 words since Ms. Travis helped me with some additional wording. 6 words from the current recidivist statute. For anybody that doesn't know, Georgia law provides that if you've committed 3 or more prior felonies and commit a subsequent offense, upon notice by the state, the judge is required to sentence to the maximum, and that any time served has to be served without parole. So, for example, if the offense carried a 20-year sentence, the judge must sentence up to 20 years, but can probate all but whatever the judge sees fit, unless there's a minimum mandatory. They would remain on probation for the rest of that time. Sometime, and I don't know whether it was during the 80s, it might have been a little bit earlier than that, they included these unfortunate words, other than a capital felony. And that had to do with the death penalty before we had life without parole as an alternative. And it's resulted in the unfortunate circumstance that the only 2 offenses to which that actually applies is murder and kidnapping with bodily injury, which means that murderers and kidnappers are treated more leniently than any other felony offenders under our code. By striking this language, we would just make it clear that this statute applies also to murder and to kidnapping with bodily injury. And with that, Mr. Chairman, I'll take any questions the committee has.
Thank you, Mr. Levitas. Chairman Ramsey, I know you just came in. This came out of subcommittee, correct? Is that a correct statement?
This is the capital felony bill that we did the other day, 133.
Do you have any, not that you necessarily have to, but I mean, do you have any comments on that you'd like to make, just for the good of the order?
No, it was a unanimous do-pass recommendation, Mr. Chairman. The subcommittee deliberated on it for a few minutes, and essentially it was a good bill.
Thank you very much. Questions from members of the committee, Mr. Franklin?
I have an amendment at the proper time.
Thank you for the notice on that. Ms. Abdul Salam.
Thank you, Mr. Chair. I just have a question. When does this go into effect, Representative?
It would go into effect upon signature of the governor.
Okay. No?
July 1.
July 1.
July 1 of
July 1,
2010?
I stand corrected. 2010.
Should that not be included, I guess?
My understanding, counsel can correct me, if it's not in there, the default position is that.
Thank you.
I see no further questions. Mr. Gary Moss with the DA's Association would like to be recognized on House Bill 901. Sure. Come on forward. Good speech. Well received comments.
For the record, I'd like to know that District Attorney Moss did give a thumbs up.
Okay. Duly noted. All right. I see no further witnesses. I see no further questions. Pleasure of the committee. What is the pleasure of the committee? Ms. Ramsey.
I move do pass HB 901. That's LC 293992.
Is there a second?
Second.
It is seconded. A motion of due pass LC 293992 and a second. Any amendments, Mr. Franklin?
Thank you. This is an amendment to line 11. A little past halfway down that line between the words or and of, I move that we insert the words any of the constitutionally authorized crimes, so that line 11 would read, convicted under the laws of any other state or any of the constitutionally authorized crimes of the United States of 3 crimes which.
Is there objection to the amendment? There is objection to the amendment. All in favor of the Franklin amendment, please signify by saying aye.
Aye.
Opposed? No. It appears that the amendment is not adopted. Mr. Sessler.
Parliamentary inquiry, Mr. Chairman.
Yes, sir.
Just for the good of the order, I wanted to ask Representative Franklin to explain his amendment.
Oh, I'm sorry, I didn't see your light. I apologize.
I apologize. I know the chair doesn't want to spend a lot of time with it, but I would like to just understand it if I could.
Not at all, Mr. Franklin.
Just that for a proper clarification that the states have authorized the federal government to do certain things, and there are certain crimes that they are authorized to enact that the states have authorized in the Constitution, our compact with them. And I thought that would be a good clarification.
Does that answer the gentleman's question?
Thank you, Mr. Chairman.
All right. Are there any further amendments? Seeing none, the question occurs on the due pass motion of House Bill 901 LC 293992. All in favor of the motion signify by saying aye.
Aye.
Opposed? No. The ayes have it, and the motion is adopted. Mr. Everson has House Bill 180. If it were only that easy.
Second.
Thank you, Mr. Thank you, Mr. Chairman. Ladies and gentlemen of the committee, once again, House Bill by substitute 180. It came before this committee in 2008, received bipartisan unanimous support, voted out of this committee, then voted overwhelmingly on the floor of the House, but it did not make it out of Senate Rules Committee, so it was recommitted. And we didn't move it last year, so we are moving it again this year. Basically states that under this provision here, it would allow permanent cosmetic technician the ability to do cosmetic procedures 1 inch above the eyelid. And that's for those citizens across this state who have undergone radiation and chemotherapy, who've lost facial hairs, and they want to retain some sense of normalcy. So this will allow those permanent cosmetic technicians to perform this procedure under the supervision of physicians or their assistant.
Is there any change whatsoever?
No, Mr. Chairman, no
in
change
terms of
whatsoever.
what the committee passed last year?
No, sir.
Okay. Questions, Mr. Franklin?
At the proper time, I'd like to offer an amendment.
Thank you for the notice. Any questions for the author, members of the committee? Seeing none. No one has signed up to testify on it. What is the pleasure of the committee?
Move due pass as amended.
One step at a time. There is a motion of due pass by substitute of House Bill 180 LC 294008S. There is a second. Are there any amendments, Mr. Franklin?
Yes, sir. As I commend Representative Everson for this bill that opens up a little bit more freedom, due to my concerns, just wondering why it would be unlawful to do the practice of tattooing. I offer it as an amendment to strike on line 10, beginning with the word it, through line 14, ending with the word misdemeanor, and replace with the word reserved, which would allow tattooers to do this. I think you put that after the reserved, don't you? Up to the period, okay.
Any further discussion on the proposed Franklin amendment?
Mr. Chairman, if I could speak to that proposed
Yes, sir.
amendment.
Yes, sir.
I would strongly object to that. This was a great compromise between the Medical Association of Georgia and the permanent cosmetic technician. For safety reasons, we do not want to open this up to every tattoo artist throughout this state. And this was the great compromise mediated between those parties involved. And I would urge the committee to vote this amendment down with all respect.
There is an amendment proposed by Mr. Franklin. There is objection by by Mr. Everson. All in favor of the amendment signify by saying aye.
Aye.
Opposed? No. The amendment is not adopted. Mr. Setzler? He waives. There's an outstanding motion of due pass by substitute LC 294008S. Any further discussion? Seeing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? The motion is adopted. Last week we spoke, this is House Bill 1015. Last week we had a good dialogue on this bill. There's a substitute in your folder, LC 294120ERS. LC 294120ERS. It came down to, and I actually don't have the old version in front of me. I don't think I do. There was a question or a concern in Section 1, which I'll call the intent section of the bill, that I know the folks on the defense side had some concerns regarding evidentiary standards that might be prescribed within that section, and there was a good debate as to whether or not that was truly necessary. In light of those concerns and in light of subsequent conversations with both the prosecutors and the defense, and hearing both sides of it, I elected to go ahead and strike that provision within Section 1, so there would be really no confusion as it relates to the intent language and any admissibility instruction, for lack of a better term, that would be in there. I felt that it was better to be safe than sorry, so we went ahead and struck it. The other major piece of, I wouldn't say major piece of disagreement, but the other piece of disagreement, as I understood it then, had to do with Section, at the very end, Section 10, and this had to do with the amount of time, excuse me, the amount of time that there would be probation supervision. And the compromise that was arrived at between interested parties, including the prosecution and the defense side and myself, goes to the language in on page 7, beginning at line 202. The period of supervision shall remain in effect until the termination of the sentence, but shall not exceed 5 years unless is otherwise provided in this paragraph. That was an adequate time period for our friends on the prosecution side, and to my knowledge, represents consensus with the defense side as well. So those were the two major areas. I think we did well to err on the side of caution on the intent language, and I think that frankly has made it a stronger bill, and I appreciate the dialogue on it. Ms. Abrams.
At the appropriate time, I'd like to be recognized for a motion.
Mr. Franklin, do you have a question or a comment?
I do have a question.
Fire away. Thank you, Ms. Abrams.
And we're adding new language on 80, starting at 85, another subsection on 90 and 95. I'm just wondering, is it already against the law to communicate directly or indirectly with another any threat of injury? Is that already a crime in Georgia?
I'm sure it is, but this, of course, goes to the retaliation. This goes to a specific set of circumstances and a specific set of facts relating to retaliating or punishing or retaliating against a person for refusing to or encouraging another to refuse to become or obtain the status of a member or associate of a criminal street gang.
But wouldn't it, without that provision, beginning at on 87 through 89, and the end of these others as well, isn't there a general statute offense of making a terroristic threat or a threat to do injury?
I have no doubt that there is. I can't quote it chapter and verse right now, but of course this does relate specifically to prosecution under the Anti-Gang Act. and that, which of course is the whole point of the bill, that it separates that out as an additional offense. Assuming, again, to be very clear, the underlying predicate act has already got to be proven, and this is another step the prosecution has to take in order to prosecute under the Gang Act.
Thank you.
Thank you. Ms. Abdul Salam.
Thank you, Mr. Chairman. One of the concerns raised in the last discussion was the issue of associate.
Right.
And I noticed that it's still in line 74, but it says to become a member or associate of a criminal street gang. So we're going to leave the word associate in.
We are. Here's the reason. You've got a lot of people in these situations who are perpetrating the very same conduct that a member would do, but they're not officially members. So what happens is a practical matter that when there is an investigation and potential prosecution, they come in and say they're not, oh, no, I'm not a member. And that's a true statement. They're not a member. And under the current law, that limits the discretion. It limits the ability of our prosecutors to get the charge that they need if they can't go ahead and go after the bad guys who may not be officially members but are clearly everything other than a member. They may be a prospective member. They may be, not a member at all. They may be in some sort of, criminal business enterprise that has to do with it, but it allows them to go and cast their net wide enough so they go ahead and get that activity, that conduct, and not be limited by the, by the term member.
And I guess, I understand about the member, but I guess the word associate in the explanation from last week, then I could be an associate. If I've got relatives or somebody that I associate with that may or may not be in the gang, am I considered an associate under this definition?
No, because they still have to make a showing that it's an associate of the gang. They have to make that nexus between.
I just want to make sure
activity.
because
Sure.
you got families where two of the brothers or sisters are in it and the other one's not, and because they're in the family, are they considered criminal gang members as well? And I just want to make sure we don't. One further question, if
Yes,
I may.
ma'am.
Back over on page 2, I noticed in line 58 that the word street was struck. Is there a particular reason?
That's for uniformity of the definition, if I remember correctly.
Because it's everywhere else.
Oh, I see what you're saying.
Uh-huh.
Let me get clarification on that from counsel just to make sure we haven't missed.
There's a definition of criminal gang activity, and there's a definition of criminal street gang if you look at 16-15-3. So criminal gang activity is another defined term.
Separate term. Thank you, Mr. Chair.
Okay. Ms. Benfield.
Thank you. I just have a quick question about the GBI funding on Section 7, page 5, that's subsection A on 149. And I apologize if we've already covered this, but has Keenan Nix or anyone with the GBI talked about the possibility of us having funds to maintain a database? Because I think that's a real important aspect of this legislation.
No, I mean, as a practical matter, when we were going through the drafting of this in the fall, late in the year, there was a concern, and not surprisingly so, about the funding mechanism, and that we finally landed on, well, maybe the wisest course of action would be to go ahead and put the authorizing language in there. My sense of it is that the GBI and related agencies would have no problem implementing that, and it gives them some discretion as to how they do that, and then, of course, they interface with local law enforcement after that. But, of course, as we all know, this is coming down to a funding matter. I would not have, and I'm sure that's shared by all of us, that we would want to go ahead and put funding in there. I mean, language in there that we couldn't go ahead and fund.
Oh, and I understand that, and
Yeah.
I think that's perfect to put the subject to language. But my question is, have we gotten any indication from GBI whether they think this will be funded or not?
This year?
Yes.
I have, to answer your question directly, no, I have not received any feedback from GBI as to whether or not they think this would be funded this year. As a practical matter, I can tell you the answer is no.
Okay, thanks.
But, we'll, as we climb our way out of this thing, I think the good part about including it is that when we climb our way out of this economy, it puts us in a position so that we can go back to law and say, look, this has been on the books hopefully since 2010. Now it's time to go ahead and put our best foot forward in terms of funding. That's, of course, an appropriations question, which is above my pay grade. So,
Mine too.
thank you.
Thanks.
Any further questions? If not, Ms. Abrams. She's not. Oh, that's all.
If I could make a
Mr. Levitas.
substitute motion of due pass for Ms. Abrams.
I appreciate that. It's always good to look to your right and look to your left, right? One of the few things you learn early on in life, look to the right, look to the left. It's true now. Motion of due pass by substitute, LC 294120 ERS by Mr. Levitas. Thank you. Is there a second? There is a second. Any further discussion? Any amendments? Seeing none, all in favor of the gentleman's motion signify by saying aye. Aye. Opposed? No. Record reflect one no vote, and the motion is adopted. Thank you. Let's turn to House Bill 927. Representative Jacobs, thank you for your patience.
When you're ready?
Yes, sir.
Thank you, Mr. Chairman. House Bill 927, of course, is the anti-bullying bill. I first want to say that and reiterate that the general approach of this bill is to give parents and local school systems more tools to deal with what is a very real problem in our schools, and to better define what bullying is. And to strengthen the law in this area. I have made a couple of changes based upon comments at, and by the way, the sub we're working from is LC 294143S. I have made a couple of changes based upon the comments at the most recent full committee meeting. They are meant to address some concerns that were brought up, but I do want to be clear that I think that it is not possible to define bullying in such a way that you say that if you strike a student in a certain way and it causes a certain injury, that's bullying. But if it's not, but if it's something else, it's not. Bullying, by its very nature, has to be to some degree defined in general terms, and that's just a fact of dealing with this issue. But I think we now have a definition with some changes that were made after the last committee meeting that really gets at what bullying is. So let me point to the changes in the legislation. I should also say that I did some additional homework after the last meeting and came to find, can you turn the mic down a little bit, Mr. Chairman? I think
Are you saying that you don't need the volume that loud?
I think my voice is quite booming. I did some additional homework after the last committee hearing, and found a pretty good clearinghouse for all of the state laws in this area. I have learned that there are 41 states with bullying laws on the books. Georgia's law, believe it or not, is the oldest of the 41 states. So a lot of states have done a lot of work in this area after Georgia did work in this area, and it is time to update Georgia's law. And frankly, many of those states have a definition. Now, I'll tell you, I took this the definition that's on lines the elements that are lines 28 through 35, although they've been adapted based upon comments that have been made. Those elements were taken from the bill that Chip Rogers sponsored back in 2008, and those elements were taken from the bill that Chip Rogers sponsored in 2008. And as it turns out, those elements are in many of those state statutes. So clearly, that was a bill that was, that built upon what other states have done. Now, I've tightened up the definition by adding the language on lines 26 and 27, which a reasonable person would perceive as being intended to threaten, harass, or intimidate. So, for purposes of the definition, as it stood the last time we were in committee, all that was necessary was it occurs on school property or involving school property, that it's an intentional act, and that it does one of these things in subparagraphs A through E. Now, okay, I think we're hitting upon what bullying is, okay, and that is occurs on school property. It's an intentional act. It has to be something that is perceived as being threatening, harassing, or intimidating, and it has to do these things that are in A through E. And as you'll recall from the subcommittee discussion and the last full committee discussion, everything in A through E involves a heightened standard. There is heightened language in each one of those elements. And there's one additional change in the definition section, and that is that I have added in subparagraph A, substantial physical harm. So you've got substantial physical harm, visible bodily harm. Those are two different terms. And they are both used in the battery statute. They're both used in the battery statute. The difference between the two is that one of them is specifically defined in the battery statute, visible bodily harm, and then substantial physical harm is defined by case law. But I looked at the case law. I'm not just roping in case law willy-nilly. I looked at the case law, and what the cases essentially say is that substantial physical harm is akin to visible bodily harm. It's just not visible. Okay, it's not perceptible to the eye. And one of the cases, a good example would be a perforated eardrum. Can't see it, but it's pretty substantial. So that's one additional change to the definition. But I think with adding this language, we have a very good the language on lines 26 and 27. We have a very good definition of what bullying is. And then the other addition was a concern that was brought up by Representative Hatfield at the last committee meeting, which is who makes the finding that is provided for on line 41 and on line 53. So I gave some thought to that about who would make the finding there. I think clearly the finding on lines 41 and 42 is, and remember what I had said previously, that that this bullying statute is within the subpart of the education code that deals with public school disciplinary tribunals. I think it's clearly that tribunal that makes the decision on reassignment or to an alternative school after a third incident of bullying. So I've made that express in the in lines 41 and 42. And then with regard to notifying a parent after a finding is made, I think that it's sufficient that finding be made by a school administrator. The whole point is the whole point of that is to let parents know that an incident has occurred. So those are the changes to the bill from the last version. I will be happy to answer any questions that the committee may have, and I imagine you might have a couple witnesses.
Mr. Franklin.
Thank you, Mr. Chairman. On line 76, well, starting on line 75, the requirement that a parent, guardian, or other person who has control or charge of a student who is a target of bullying. I like that phrase that you use, their target of bullying, and is wondering if you would oppose using similar language on line 50 and 54, where we were saying separating the student from his or her target of bullying. And the same on line 54, offense of bullying or is a target of bullying. Would you be agreeable with that? Just to be consistent throughout the bill?
Let me ask Mr. Franklin just to go ahead and point out that location again, if you wouldn't mind.
It is on line 50. Just change the word victim to target of bullying. And on 54, it would read offense of bullying or is a target of bullying. And the reason I asked this is because since you have up in line 26, it could be an intentional verbal threat that may or may not truly be there. You could just have someone mad and so it's just a target of bullying, and maybe the person isn't really a victim, but they're just saying they're a target of the bullying, and I think that would be more clear and more consistent using the same terminology throughout. Norm, would you be okay with that language?
Well, I would leave that in the breast of the committee. However, I will say that the use of course, you're just talking in subsection C about the model policy, and on lines 50 and 54, the use of the word victim there is after a finding is made. So I do think the contexts are a little different, but it's an issue I'd leave in the breast of the committee.
So you're saying those are after the finding. Could you kind of point that line out, that it's after the finding?
Line 41. Is that right?
Yeah, I mean, you'd be looking.
Gotcha.
Yeah, I mean,
upon a finding. Gotcha.
Yeah, I mean, it's both of them are upon a both of them are upon a finding of one sort or another, depending on. I mean, both of them are upon a finding.
I know. I see
Paragraph 2 involves a finding, and paragraph 3 involves a finding.
Great. Thank you. Thank you.
Ms. Abrams.
That would be my point. I would just, I know we may discuss it. We may discuss it later, but I would. Well, I do understand Mr. Franklin's concern. I do think in line 50 and in line 54, the finding aspect is very important because you're now changed. It's semantical, but it is very important because at this point you found that there's someone who's actually been the target and has been proven to be victimized.
Ms. Cooper.
Representative Abrams made my point, so I'll pass.
Okay. Ms. Abdul Salam.
Thank you. Representative, going back up to page 2, line 26, 27, where it begins about a reasonable person would perceive as being intended to threaten, harass, or intimidate. Who are you meaning would perceive it? The potential victim or target, as Representative Franklin says, or some authority figure that they've reported to would perceive it?
Well, neither actually.
Oh.
It's a standard that is pretty, that is developed in the law. I mean, reasonable person is a term of art, and it's meant to say that it would have to be, just generally that generally speaking, a person would perceive it as, generally speaking, threatening, harassing, or intimidating. I mean. That's what it's not. I mean, obviously, there are times when school administrators are going to be making a determination based upon the definition, but they're applying a standard, and that's a standard that is meant to be referenced there.
Thank you. And one other thing that I'm glad you added, the substantial physical harm. Does that also include psychological, emotional? Bullying. A lot of it is psychological and emotional bullying.
Yes, and I think the definition, and as we've discussed in a previous meeting, I think the definition encompasses that.
Let me just clarify that. When you say the definition encompasses that point, tell me what your reference on that is. Is it in 23.1?
23 point. No, I think that once you're at that stage, you're talking about something that is, that has the effect of substantially interfering with the student's education, that is so severe, persistent, or pervasive that it creates an intimidating or threatening educational environment. I mean, I think once you're at that stage with, psychological distress, you are rising to that level.
Can you just play it out with me if you could? Could you have an intimidating or threatening environment without that harm? I'm trying to make sure that we do encompass the psychological harm as well in case there's not physical harm. And if I'm missing a clause, just tell me. I just want to make sure that we're capturing that as well.
I would believe it is captured.
Would it have to be captured within the definition of 16.523.1 on line 29? Or
well, 16.523.1 is the battery statute, right. So you're talking about a touching at that.
I'm just trying to figure out where the reference point is so that we can make sure that we're capturing any psychological harm as well. Ms. Abrams?
Mr. Jacobs, would you agree that it's captured? I think what you're saying is that intimidation by its very nature is mental harm, and that the mental harm that you're trying to capture is basically it's captured by B and by C, subsection C and D, so lines 32 and 33 and 34, because to be more expansive about that means you might have to actually go through a finding of mental harm. I mean, you're creating a higher standard if you try to more specifically delineate the language in this. And I think this captures the intent that Representative Abdul Salam is getting to without creating another barrier for the students to actually prove that there is some mental or mental harm to them, because there's a separate statutory set of responsibilities that I think you'd have to involve if you did that.
I really do believe the language on lines 32 through 34 captures psychological harm.
I do too now.
Okay.
Thank you. Ms. Bird.
Thank you.
Thank you very much, Representative Jacobs. I think I'm looking at lines 45 through 50, and it talks about a student who commits one or more offenses will someone can determine that they have to be moved to another school. And if I remember the other day, it was outside the jurisdiction of where their district, where they go to school.
Right.
Okay, first thing, who is going to pay for that child to be moved to another school? By transportation?
The transportation generally is paid for by the parents, and that's provided for in the rules that govern. I mean, I think I need to be clear from the outset. The language in lines 45 through 50 really is a restatement of existing law and existing procedures. It's just put there to let parents know that this is an option, this is something that is available in this situation. But the reality is that how transportation is dealt with in this scenario under this power that school districts already have is already spelled out. Is already spelled out in the rules and procedures that govern how this is done.
All right, and follow up, please. Also, for a parent that believes that his or her child is being bullied, and would they not expect that their child should be moved to, or that child should be moved to another school? Would it be an automatic expectation that that child should be moved?
Oh, absolutely not, because and again, I mean, we were very intentional to rope in the rules and procedures that that govern how such a transfer is done, because there's a whole administrative hearing process. It is not automatic.
Very good, thank you.
Mr. Ramsey.
The language you added in line 41 and 42, providing who is going to make the finding with respect to the bullying. Are you saying they have to make a finding only prior to the automatic transfer, or do they have to make a finding that each of the three occurrences of bullying along the process? So essentially, I guess the way it will play out in your mind is the school officials will, at the given school where the bullying has occurred, will petition to the tribunal or the panel that we have had 3 incidents of bullying. Then they have to make that showing, or is that something that the tribunal will have to say? Okay, yes, we're certifying as to each incident of bullying. How's that going to work?
Well, I think
I think it's, and I guess I'm asking that because right now under current law, are you aware of how this is played out? Because right now it exists a mandate that they send these students after 3 incidents of bullying occurred. Is this how it's working under current law?
I believe the answer to that, and this is just based on kind of anecdotal conversation, okay? This is not with me having done research, but I think the answer to that is yes. And I think that ultimately the way it works is that the disciplinary tribunal has to make a finding that because it's a legal proceeding essentially. I mean, it's before a different kind of body than the court that you and I would practice in, but it's a legal proceeding ultimately, and you have to make a showing that there have been 3 incidents of bullying.
The only reason I ask you, I'm the second signer on the bill. I'm a strong supporter. I don't want to add a procedural barrier that's going to make it more difficult than what exists under current law to transfer out a 3-time bullier. And if this is the way it's playing out under current law, I'm comfortable with it.
This is, I believe, the way that it's playing out under current law. And furthermore, we really aren't, with respect to the 3 strikes scenario, 3 strikes and you're out scenario, we're really not changing the substantive law on that point. I mean, I think it is currently done by a disciplinary tribunal because it's in the disciplinary tribunal part of the code, and whatever procedures go into that proceeding are not changed either because that's also existing.
Right. And Mr. Chairman, at the appropriate time, I would like to make the motion.
Thank you. Any further questions for the author? Seeing none, thank you, Representative Jacobs. James
Thank
Wilson.
you, Mr. Chairman.
Thank you. Mr. James Wilson. With the Georgia School Superintendents Association, in my continuing mastery of the acronyms. Welcome.
Thank you. I'm standing in a little bit here for Herb Garrett, who is the Executive Director of Georgia School Superintendents Association. I'm a retired interim superintendent in Cobb and a retired superintendent from Fulton County Schools over a year and a half ago. We certainly support and appreciate the hard work that you have done in this bill. We only have one suggestion, and you may have actually covered it, Representative Jacobs, in your comments, that on line 47, we would either suggest or ask for clarification to add this, of bullying to a school outside the student's attendance area, and this would be the insertion, comma, transportation provided by the parent, and then continue as it's stated there. I think it's already. If it's already covered, then we're. But we obviously, as school system administrators, would want that burden to be placed on the parent.
Questions for Mr. Wilson? Ms. Cooper.
Thank you, Mr. Chairman. I don't have one for Mr. Wilson, but where is it covered? And would there be a problem with clarifying it here? Because we've talked about making the law very clear for people who read it.
Sure. I mean, I wouldn't have a problem with including the language, Chairman Cooper, but and if you need a specific site, I'll be happy to obtain that for you or figure out exactly how that works. But it is my understanding that current rules and procedures, which are wrote in here, spell out who is responsible for transportation. If a student is reassigned. So I think I believe rather firmly that it's already addressed.
Is that addressed when you have expulsion situations or suspensions? You have those situations right now. Yeah, or an alternative school. Representative Barnett has chimed in with that, which I think is a good point. I mean, where you have an alternative school situation or a suspension or some sort of disciplinary procedure or process. I mean, that the parent's responsible for the transportation now. Is that a correct statement, Mr. Wilson?
In most cases, and in some school districts, though, they do provide transportation to an alternative setting if it's been a long-term suspension.
Mrs. Cooper, did you have a?
I guess we talked about how a lot of times, because we have so many places in the law and most people who are reading it are not lawyers, that whenever we can, to clarify our specific issues when we're writing a section, it wouldn't hurt to repeat or put exactly what we think, even though this may be in another part of the law. To make it very clear, if some parents go to the bullying law by some degree or their lawyer goes to the bullying law, it's right here that says, they're responsible for the transportation.
Sure. There are two over there, so.
The concern that I would have with that, Chairman Cooper, is this. Say there is and this is why I want to leave it in the general terms of rules and procedures that govern these sorts of transfers. If there is a school district, okay, that is part of the way it does business, is willing to provide transportation, all right, I don't want to put in the statute that you can't provide transportation. I mean, if we put that wording in here, then we're saying that when you've got an incident of bullying and you decide as a school district to transfer the student, no transportation, and that's what I want to get. I don't want to dictate that by way of the statute.
Mr. Chairman.
Yes, ma'am.
Well, then it would be easy to say transportation provided by the parent unless otherwise provided by unless the school system provides it or something. And Jill, were you looking up the thing? Is it in the other part of the law?
My sense is that you may create some problems even by doing that. You probably, my sense as of this minute is that you may want to just leave it alone in order to give the school system the discretion if they want to do that.
Right.
Mr. Wilson, you look like you need to say something. Sure. Come on to the other. Well, there are two mics there, so. Okay.
One, we don't want to give you the wrong impression that we don't support what you've done here, because we know you've worked very hard at this, as well as the entire committee on this. The difference could be on long-term suspension. Sometimes school districts will send them to alternative schools. This states that they would go to another school. So systems certainly like the ones that I participated in Florida and Cobb, and really all districts across the state, if you start trying to provide transportation to every child to an individual school, you could really run your transportation cost up, because you're transporting one child to a school, where others, when you try to send them to an alternative school.
But right now, it's within the discretion of the school district, correct? Is that an accurate statement?
We believe that. We just like to make sure that it stays that way. And
I mean, my sense is that it's in the discretion of the school district right now. So maybe the wisest course of action would be just to leave the discretion as is.
We just want to be sure. We appreciate it.
And as a practical matter, as the bill moves on, whether here or in the other body, that's something that if we discover that we're just completely wrong on that would be, I mean, my sense of it, this would be under an open or a modified open rule and subject to amendment with whatever notice according to the rule, or if it, or in the other body, assuming passage here. So my sense of it is that shouldn't bog down the motion on the bill now, but it just take a quick look at it, subsequent. If that's all right with everybody.
Okay.
Mr. Thompson.
Mr. Chairman, my comment to that would be we're requiring the local board to make a policy as part of this, and they could address it in the policy and simply say, if we do that, we're not going to provide transportation.
Well said. Ms. Benfield.
I was just going to raise a point that had already been raised. I had the concern about schools that are voluntarily providing it being preempted by this.
Okay. Mr. Sessler.
Mr. Chairman, to the association, I would tell you if we had taken the language as you had suggested, this statute could be read to say that the parent shall deliver the child to school. It says, because it will say with transportation being provided by the parent. On its face, that could be construed to say if your child is being transferred out of the district, mom must or dad must drop him off, as that reads. I know that's not your intention. Perhaps if you were to offer this or an amendment were offered somewhere later on the floor or in the other chamber, words to the effect of nothing in this code section shall be construed to require a school system to provide transportation, something like that. That's open and permissive, but not quite.
Any further questions for Mr. Wilson? You thought he had made a clean getaway.
I was trying.
All right.
Everything to go. Thank you.
Thank you, sir. No other witnesses for House Bill 927. Mr. Ramsey.
Mr. Chairman, I move, I guess this is the author's substitute. It's LC 294143S to HB 927. I move do pass.
Gentleman moves do pass LC 294143S, House Bill 927, seconded by Ms. Abrams. Any further discussion? Any amendments? Seeing none on the gentleman's motion, all in favor say aye.
Aye.
Opposed? The ayes have it. The motion is adopted and will be reported as such. Thank you, Representative Jacobs. Thank you, members of the committee. We have a meeting scheduled. Hold on. We've got a meeting scheduled this coming Monday. As of right now, this Monday at 9:30 a.m., which is a recess day. We've got a couple of bills to take up, and we're also going to be having a hearing only, on House Bill 571, which has to do with our sex offender laws. I'd encourage you to please be there. It's a hearing only, but it's a very comprehensive bill, and I think it would be time well spent. As of right now, there's no meeting on Friday, and I do not anticipate that there will be one, trying to be respectful of members' time during the recess. Ms. Byrd, did you have something?
It's my day to feed my family for the month.
All right. Thank you. We're adjourned.